to be hosted by Advocate Mantula. Like many others in the country, he seems to have challenges with the network. But then he said he will, as and when it's possible, join us in the discussions as we go on, if ever it will be possible. Those are the two things I thought I should start with and explain. Are we together? What's happening? Hello, everybody.
Yes, Mr. Chidi, we can hear you.
Oh yes. Sorry. Yeah. I was attending to the live streaming part. We are on YouTube. As I said, it's a live stream, but then it's recorded automatically on that platform. So you can always share the link later on with the rest of the public. Welcome, everyone. Dr. Kalani, and thanks for gracing this platform, and our focus is to create that content, and you always should try to get it from the best. Thanks again for having us at this session. We are the Africana Justice Association. I'm going to be the host this evening. We've got a few people. Let's introduce each other. We can start with, on the screen here, I see Martin. We can start with him and go to others. Mr. Kuyana?
Yes, Mr. Chidi, indeed. My name is Martin Kubiani, one of the founding members of the Africana Justice Association. I'm happy to be here. I'm excited that we have Dr. Sello Galane in our midst. Some of us, we grew up listening to his free kiba music. Most particular, what comes vivid in my mind are his performances at the State Theatre in Pretoria. So yeah, I'm excited to be here, Mr. Chidi. Thank you very much.
Thank you so much. Can go to the next person. Just be ready, whoever can come through. Thank you.
Thank you, members of Africana Justice Association, and good evening to our speaker for today, part of Horror Conversation, Dr. Sello Galane, and to you, the host, Mr. Matumi Chidi, and all the members of the association. My name is CJ Ntswani. Africana Justice Association is my second home. I'm a practitioner based in Polokwane as a law practitioner. I'm also a member of the Black Lawyers Association in the province, and excited to be part of Horror Conversation for this evening. Yes, I'm willing to hear and to share ideas, and yeah, I'm grateful to be here, and thank you once more for the invite and making it possible to have this type of conversations. Much appreciated. Thank you.
Thank you, Malida. Next person. Introductions. Okay. We'll get to know each other as we go on. From time to time, you'll chip in and introduce yourselves.
Good evening, everyone. Chobela. Good
Welcome.
evening, everyone.
A very good evening, a very good evening. Thank you.
Oh, thank you. My name is Mahata Tipalepale. I'm a literary activist. I'm also a supporter of Horror Conversation, and I'm happy to be here in particular because the host, Dr. Sello Galane, is one of the people that I respect most. And as somebody who has read his thesis on the work of Malombo, Dr. Philip Jabani, I'm more interested to understand what he has in store for us. Thank you very much.
Thank you, Sis Mahatla. She's always with us. The next person. Yes, as we go on, let's let's do it this way. Let's do it this way. Let's bring in the guest. What we will do from time to time, we'll invite participants to introduce themselves, or alternatively, they can do that as they participate in the discussions. Welcome again, Dr. Khalani, this evening.
Welcome. Can I open the video?
Yes, welcome. Thanks very much.
All right.
Yeah, yes. Okay. The topic it's mainly focused on the works and copyrights, and how, as a people in this country and possibly other parts of the world, such rights and works are lost to the West. Can you take us through the topic, Dr. Khalani?
No, thank you very much. It's a great pleasure to be part of this great initiative of legal minds who intend to share views and to kind of chart the legal landscape, legislative landscape as we go along. This area of copyright is it's what I would call the blind spot in ordinary life of South Africans. I call it a blind spot in a sense that it is highly specialized. It's highly regulated in law. It is sometimes, dealt with in fundamentally uninformed and misguided way, because you would find us dealing with issues of copyright and thinking that we're dealing with issues of patents. And you find that we're dealing with issues of copyright when we are actually dealing with issues of IP in general. So what governs inventions with regard to the patent law, and what governs the very important statement I'm coming to make now. What governs works that are conferred copyright by statute. So those works are a limited list in law. Not everything, therefore, becomes eligible for copyright. And this is very important. I've seen a lot of discussions wasted when people are not aware that you do not have copyright because you are a great writer of something, or because you are a great composer of something. You've got to check, because copyright is a creature of statute. Now, if it's a creature of statute, it means that what the law in terms of Copyright Act number 98 of 1978, in particular, as the principal legislation, because then it has got about 7 other amendments after it, whose details are often lost in the discussion. And generally, one would ask, often when people discuss copyright law, then you would realize that the people who are more articulate and more pronounced are performers or musicians. But if you look at what copyright law fundamentally entails, It is in terms of section 1.2. If you look at that, it says works eligible for copyright are the following, and it says subject to the provisions of this act, the following works, if they are original, shall be eligible for copyright. Now, literary works, poems, novels, and all of that are the first. The second, in terms of 2B, it's musical works. And we must understand what musical works are. And then the third one would be artistic works. And we need to understand what artistic works are. And cinematograph films. And then you would have sound recordings. And then you've got broadcasts. And you've got program carrying signals. And then you've got published works. And the last one is computer programs. Now, as Africans, out of the 9, the list of 9 that the copyright law prescribes as only those that it confers copyright to, you cannot add the 10th one because you like it. You can't add the 11th and the 12th one because you're passionate about it. No legal representative will be able to take your court, your matter before the court, because he would have no law statute to rely on in presenting your matter before the court. Because your matter would be moot ab initio. It would be moot before it even begins. It would not be catered for in law. So every legal practitioner knows that you've got to rely on an empowering provision of a statute to then develop your legal question so that you can be able to develop your motion proceedings and for your heads of arguments and all of that. Now, it's very important that we remember all the time what the 9 are. And because every time when this debate, ensues on radio and TV, it's all about music, 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 music. And if it's about music, the distinction is not even made between musical works and sound recordings. Now, what is the difference? A composition, which is the melody, it's a musical work. The lyrics of a song are literary works. Because 9 out of 10 times it could be that the person who writes very nice instrumental music is not a literary writer, so can't write nice lyrics, and would have to ask somebody else to write for him or her. Now, that work, just comprising lyrics and melody, would simply constitute 2 works that are protected in terms of copyright law. And the other part is that what we call sound recordings. It is the final product on a CD or digitally that comprises both the musical work, which is the melody, the song itself, and the lyrics. Now, both of the 3 are part of the 9 that copyright law confers copyright on. But it is very important for us as so that we realize that we're only talking about 1978. Ever since Africans, for example, were in this continent, were in this country, we have been singing, we have been dancing, we have been creating lyrics, we've been creating melodies and so on. What protection is therefore available for all those works right up to 1978 when the copyright law was introduced? There were recordings that were done from 1927 right through the establishment of Gallo, 1933, right up to 1978, when the copyright law was then introduced in this country. Then who has, on what grounds are all those works that were done for that entire period, on what grounds are they archived? Who has them? Who was ruling this country during that time? Who has recorded those works during that time? Now, if we talk copyright, we must not forget the artistic works, the works of art, that would over and above be part of the three works that would be the musical work, and that would be the literary work and lyrics, and then that would be the sound recording. And then you would have a design in front of the cover, which is another work that is protected. Now, what is important is that copyright law is limited to the 9 works. And it's very interesting to note this, that the copyright is conferred to the works. Conferred to the works. Now, in terms of the human rights culture, where is the writer? Where is the composer? Where is, because prior to 1978, you have the 1967 Performance Protection Act 11 of 1967. So once you've got that, then prior to it, you've got the Rome Convention of 1961. Now, these two are part of international law that was governing the space prior to 1978. And what was the politics and politics of all colonies of Britain, of France, of Germany, and so on during that time? You would find that it is not amazing that you would find most African works sitting in different archives and museums of the world. You would not be surprised to find the Vatican in Rome having most artistic works than we would have in all our archives in the country. You would not be surprised when you find a lot of designs which would be part of artistic works sitting everywhere else in the museum of the world, and when other African countries now are calling for the repatriation of those works. So basically, when we deal with copyright, we must not forget computer programs. We must not forget computer programs, because computer programs are protected to an extent by copyright. And South Africa has a category of computer programs as part of the works protected, and software can be protected through a combination of copyright and patents. Although Patent Act says that a computer program is not protected by patents. So it then depends, because there are exceptions though that the law allows. So software names are protected as trademark and registered designs in things like a geographical user interface. Software is a wider concept than computer program and are protected by copyright. So once we understand what works are protected by copyright, it then becomes important, because amongst us here could be some people who are writers. And it's important that when we deal with a book, for example, it is one object, that consists of three legal objects. One, it will comprise of a literary work, which is the text itself. It would comprise of artistic work, which are the designs of the cover and the pictures and the photos there. And then it would have a published edition. Now, a published edition, therefore, that is the page layout, of the book. So the latter is owned by the publisher, and we must understand that the published edition is owned by the publisher, much as the text is owned by the author, and the design of the book and the layout the artistic works would be either owned by the owner of the photo or the artist that did the artwork in the book. So it becomes very important then that generally it is assumed. If you look at what becomes very critical is what the requirements for copyright are, amongst others. You would find that if you have an idea and you and I are traveling in a bus or we're in a plane, and I raise fundamental ideas, and then you use them, and then you then create something tangible about the ideas, and then I jump and come to you and say, counsel, please represent me on a matter. You say, what is the matter? You say, no, you stole my ideas. And you say, sorry, man. Absolutely said that ideas and facts and historical data are not copyright protected. Only when your ideas is reduced to material form, that is, if you write it down. If you reduce it to material form and you write it down in your notebook somewhere, that handwritten version of your idea, the law confers copyright on it, because it now becomes literary work. But if it's just an idea that's floating and you hope that you'll generate money out of it, you will not be able to do that. Just this morning, there was a matter on radio that was dealing with an idea that somebody says, I pitched the idea, but KFC took it. Now, when legal minds were brought together, it was found that that idea should have been written down, should have been reduced to material. If you've got a beautiful idea of a song and you do not reduce it to a recording or a transcription of notes or a text of the lyrics written down, it cannot be protected. It's still an idea. It's not reduced to material form. Now, originality becomes one. South Africa has the lowest threshold in terms of the first requirement, which is originality. And then South Africa brings in another element, which is not just originality, but it says labor and skill. So it is generally regarded in law as sweat of the brow. If you show that you worked hard on a piece of work, then that work that you would have churned out, first, it must be one of the nine. Must be one of the nine that are conferred copyright by law. Then secondly, you need to show that you've really worked. Let me give you an example what sweat of the brow means. Those who have listened to my work, you would realize that you can find a song that would have generally been a well-known song out there. But the minute you start to work on some complex arrangements that show that you have done some work to give it the kind of structure, form, general, final output that it is, then that work, the law confers copyright on, not simply because it is a song, but because you have given it some originality in the way you've approached it. And secondly, that there is evidence of labor and skill. So basically, sweat of the brow, it's the threshold. Now, Canada says skill and judgment. European Union says intellectual creation. We say originality and hard work, labor. USA says creative spark. Those of you who must have followed the whole thing, there's a group of African male singers who are singing waka waka amina mina samina mina. It's time for Africa. That group was recorded way back in history. And then that recording was brought forward, and that Shakira must have heard that song and did that and used the song. But what is the USA jurisdiction saying about the requirement? The American jurisdiction says a creative spark. Now, she says her justification for ownership is that she had a creative spark one day as she was passing a particular place. She knows that once you say creative spark, you have met the requirements in terms of American jurisdiction on the requirements for copyright. Now, it is important to know what the requirements for one country are as opposed to the requirements for the other country, because South African musicians, like all other creatives, South African computer programmers, South African, writers of great artistic works, of literary works, of cinematographic films, of broadcasts, of program carrying signal, are not always going to be working in South Africa. We're going to be working in other countries, and if you do not know what the requirements for those jurisdictions are, then you hit a snag there. Some of the issues regarding copyright, in a way that it is structured in a sense that it is not just knowing what work it is. It's important to know the duration. And this is where most of us lose it. The duration or subsistence of the right on the work. Copyright Law, Act 98 of 1978 says, for different types of work, for example, if you take literary, musical, and artistic works, it's 50 years. But it's important to know how you calculate that. It's for the rest of your life, you own the work, and 50 years after your death. Other jurisdictions in Europe and elsewhere go up to 70 years after your death. But families sometimes don't take interest. It's very important for anybody who is a copyright holder to know that for the rest of your life, you own the right. And if you are the writer or developer of a program of any of the 9 works that are conferred rights by copyright, you must know that copyright is not registered. Copyright is automatic. After you have written that song and you have reduced it to material form and you put it somewhere safe, it is often the case that when we send to Samro and to Sampra and Capasso, that checks if the work was notified before and so on and so forth. It is such that when you have a matter before the court, you can call them as either friends of the court or as to lead evidence that by the time you submitted the song to Capasso, for example, Capasso cleared it as work that has not been claimed by anyone before. So they would come in either as amicus curiae before the court, or they would come in as expert to give expert evidence in court. So cinematographs, film, photographs, and computer programs. Also, it's 50 years. It's important that we know that. But what families will not know when a member passes on is how do we calculate the 50 years? From what point? It starts from the 31st, which is the end of the year during or in which the copyright owner passed on. You own it for the rest of the year, but the calculation of 50 years starts the end of the year on which you've passed on, and then it proceeds for 50 years beyond your death. So 50 years after the end of the year on which the copyright owner would have passed, then the 1st of January, after 50 years, that work falls on public domain. Now, most people who know, wait every January the 1st, the people who know how these things are done, they go and they check if there's any work that is lapsing and they take over the work. So it's very important that we know exactly what happens. And then it's different because when you deal with patents, when you have an invention, then in that particular case, you have to then have the patent registered, have it registered so that then you can be able to lay a claim on that, and that your family can be bequeathed that. So let me just bring it home, and then also say how I managed to protect my work. Sadly, if you look at what I've just explained, in summary, you would realize that I normally say, when I was invited on Newsroom Africa, then when I was invited to make an input on SAFM just 2 weeks ago and 3 weeks ago on Newsroom Africa, indicated that copyright is 99% law and 1% the work. Why did I make such an extravagant statement? I said so because if you miss all the requirements, if you do not know what infringement means, and infringement of each one is different, you need to know the infringement of each one. You need to know the duration. You need to know the requirements. And when I said 99% law, I meant all of those, because 1% is sound or text or whatever. So how do you protect some of the work? Let me touch on something that a lot of people may not be aware is copyright protected. Simple thing like makeup. Makeup is temporary art. So temporary artists who make makeup, part of the rules of the requirements for literary works is that it must have some measure of permanence. If it does not have a measure of permanence, like for example, somebody is lighting the show and the show is lit, it's beautiful, but when the show ends, the lights are off. What evidence do you have to then take forward and say, I designed the lights? It is that you have to design your lights on paper. And then you've got to design the plan and the angles and the stage and the colors, if you may, and write it on paper and draw it. In that case, when the show is over and you switch it off, and then people might say no, when they see it on DVD next time, they say no, you did not design the lights of that show, because that work falls under temporary artist work. So once that is done, you pull out the pages. You say, aha, look, this first sequence, I had to shoot 2 flags on, 1 orange, 1 red. There you see. See, look at the video. Then the second one, the sequence, the third sequence, fourth sequence, right to the end. So this is a show. This is what I did. And then it would have the stamp, it would have the date of the theater that would have produced it, and so on and so forth. So it's a very complex issue that we need to deal with. But oftentimes now, currently, the whole bill that is before Parliament, the debate around it, something that gets lost is that when we read the bill itself, inside the bill, it's not just everything new. It is the amendment that came out in 1983, where 1983 Act 66 limited copyright in certain artistic works. And people would argue today that no, but the bill is limiting copyright on certain artistic works. No, that limitation was done in 1983 in Act number 66. If you look at the same bill, obviously the bill builds on operative law on existing legislation. If you look at the bill, you find that it makes provision for copyright in published editions. And you say, no, I want to raise this matter. That part of the bill was enacted in Act 52 of 1984. So if you want to take that matter before the court, you would then need to do an in re motion application where you question the consistency with the current constitution of that piece of this piece of legislation in terms of the 1984 amendment. Because people would want to challenge the bill on the basis of that. For example, let me give the Bella bill, for example. The Bella bill, somebody was trying to mount a campaign that the Bella bill says that the Minister of Education has got powers to set standards. But that does not emanate from the Bella bill. Those powers were conferred on the minister in the National Education Policy Act of 1997. So we need to know what we are questioning in a bill and what is in the bill but is part of operative law. And if we want it reviewed in terms of its consistency with Section 2 of the Constitution, that says the Constitution is supreme law of the land, any law or conduct inconsistent with it, it is invalid to the extent of its inconsistency. So the question of to the extent of its inconsistency is very important, because the other matter that deals with to the extent the Braille Society of South Africa took the copyright law, Copyright Act to court on the question of adaptation to Braille. And that on the basis of human rights, on grounds of human rights, the blind people have a right to access material that is written in orthography, right? And they won the matter at the High Court, and it had to go to the Constitutional Court to confer inconstitutionality. So when we deal with these matters, it's important for us to deal with copyright from both the point of historical analytical survey of our legal history, as well as the substantive issues of the provisions of the law. If, for example, you want to deal, some people would even get to a point where they march to the Department of Sport, Arts and Culture about the bill. And very little would be known that already in 1988, Act 13, the question of the Copyright Act was moved from the Department of Industries, Commerce and Tourism to the Department of Economic Affairs and Technology, which today is Trade and Industry. So the bill, as it sits before Parliament, before National Council of Provinces, and before the President, in that order, it is a bill that has been put to Parliament and to the President to assent to by the Department of Trade and Industry. So it's very important for us to then know that if you want to debate that, that was already put into law by an amendment of Act 13 of 1988. So if you want to question that, it becomes an in re motion application. The computer programs were eligible for copyright only from 1992 in the Act 125. So if you want to question it in the bill, you've got to then deal with the Act itself and then challenge that piece of the amendment of Act 125. And as I conclude, it's very important for us to know that somebody insulted the entire country 3 weeks ago when Brother Caiphas Semenya raised this matter with AKA. And somebody said, no, South Africans don't know copyright. Not even your judges know copyright. Not even your advocates know copyright. Not even the copyright holders know copyright. You know, it was such a scathing attack on the integrity and the bona fides of our legal practitioners and our justices that it is very important that when we discuss these matters, we discuss it on the letter spirit of the law and not just based on what we would want to be famous about. And that, for example, the 1992 Act 125 dealt with provided further penalties for infringement on copyright. So if you need to read, you read the Principal Act, but you know, because why is it important why am I stressing the dates of an enactment of various amendments? It's because somebody is going to stand up and try to raise a matter of infringement on computer programs and cite a 1988 amendment and only the fact that you should be relying on the 1992 amendment of the Act and not speak generally. So then the Copyright Tribunal, people ask, if my work has been infringed, where do I start? You do not necessarily, it's not necessary for you to have money and you approach an attorney or an advocate to raise the matter with you in a competent court. You can approach the Copyright Tribunal, which was introduced by the 1992 Amendment Act 125. And then you appeal. You can also appeal the decision of the Copyright Tribunal, because then people like us who are both ethnographers and as well as a musicologist and as well as therefore qualified to do musicological forensics, would then look at what the law says, what the requirements are, what constitutes infringement. And when we have done that, we go into the details of, look, the creativity and creativity is not a requirement. You don't go there and say, you know, this is creative enough. It's not a requirement for musical works, for example. And then you would then have to rely, if you have to read and follow the counterfeit declaration of counterfeit as unlawful, you would not have been able to do that up until Act 38 of 1997, which was the first act post 1994. which is the first act post the 1996 Constitution, so that you would rely on to deal with those kinds of infringements. So as I close, I would say that no artist or no creative or no copyright holder of the 9 that are conferred rights by copyright should take it for granted that because you own the right and then you've got it, you take it for granted that you can sign any contract, you still have the right. You may lose the copyright on grounds of contract. If you sign the wrong contract, that does not seem to be encroaching on your rights. A simple contract like a performance contract, yes, Mapungubwe festival coming, boom, somebody says, everybody who's going to perform there must go through me. I'm the one who won the tender for Mapungubwe festival. Then these people send you contract. Somewhere the contract says, you waive the right and you cede the right. You waive the right to be recorded. And this person is not your record company, does not have the right, but you cede the right through a performance contract. And somewhere they sneak in a clause that says you agree to be recorded, because you will remain with a copyright on the musical work, but you will not have copyright on the recorded work, which would necessarily be the sound recording. Because then this person will start to put the music on YouTube, would put it on Spotify, would put it on Google apps, will put it, and you say, but you, that's my work. It is indeed your work, but you have agreed to be recorded, and you did not specify that if you record me, you may keep that in your archives, but you may not turn it into a commercial commodity. You may not generate revenue on it. And people do not know. Most of the work that you see on YouTube and so on by South Africans and creative people, they were not given, they did not kind of sign an agreement for these things to be there. But somebody there is making a lot of money. I followed up a work of some of the 4 DVD tracks that are on there that were mounted by a group of people called Zulu Boys. And little did they know that some of the 2 brothers from South Africa who work right at Google, one of them is at Harvard and one of them is at Google. So I was able to raise the matter with them, and I'm able to see in the back end how much was paid to the person who uploaded the music and is exploiting the music without the permission. So it's like I said, as I close, copyright is a creature of statute. It is not work of emotions, and I thank you.
Thank you so much. Thank you so much. A very, very interesting presentation. And that's why sessions of this nature are needed, because it's a blend of many aspects of experience, literature, academic work, a practitioner of music and of art, and a combination of all these things brings us where we are, and the necessary awareness that we need as members of society, as people interested in art and those who in art and other works, music and others, writing and others, and practitioners of law. An allegation is made that legal practitioners, judges, and all others are illiterate on copyright law. Thanks very much, Prof, for the a very fruitful engagement. Can I start with your friend, a dear friend who indicated that I should advise that he would be joining us? Dr. Moroko, are you able to come and greet Prof, and from then on we'll open space for people to engage. Prof, did I say Prof? Dr. Gala. Dr. Moroko, are you able to come through? As Dr. Moroko is coming through, let me open space up for anyone who would want to make any contribution. Just come through without raising your hand. Dr. Moroko, are you able to connect with us? I see you are muted. Satechi, Dr. Satechi, Morokolo Satechi. Do we have anyone who would want to make an engagement, or are we confused now because of the great presentation? Members of the audience, come through. Let's contribute. Maybe as they are, Dr. Halane, as they are thinking about the questions they're going to put to you, can you, in just about a minute or so, I note that you say the approach in South Africa is originality. Are you able to summarize it so that we get it very clear from you? Thank you.
Thank you. No, that's very important. It's a very important question. The first author of any of the 9 works is that particular first version. Is the original version. There are 2 original versions, types of original versions. If you translate my book from English to Sepedi, or from Sepedi to English, and then the first ever copy that exists in the translated language of my work, it's what we call, it is an original, it is conferred originality, it is conferred originality by law, but may not be exploited for commercial purposes up until you have signed or reached an agreement with the author of the original work. It is actually called derivative work or adaptation or second work. So it is original to the extent that it is the first translated version into a language, but it is not original for commercial purposes. The minute you exploit it commercially, then you need the permission and approval of the first original copyright holder. So any first work is work of originality. Translation, adaptation could be the second original piece in that language, not in the original language. But it is called derivative work, and its right to exploit commercially vests with the original writer or the original author or the original program developer. I hope that is
that helps. Dr. Moroko, are you able to come through? I see Dr. Satechi has raised a head. They say the Moroko and Satechi always confuses me. Dr. Satechi, are you able to come through? He had raised his hand. Perhaps sorry.
Maybe whilst you know, other participants are contemplating the the presentation. May I also raise that every law legal scholar and a law practitioner knows the hierarchy of our laws, and that Section 39 does provide that we must, in interpreting the law, every tribunal, forum, or court must consult or rely on international law. So where does it come in the development of our laws? Because it's very important for us to know, because our national law is dependent on international treaties and agreements. For example, let me just deal with how a copyright law comes into being. First, it's that the process is that from the Department of Justice and Correctional Services, they've got to check the alignment of a draft with domestic law, and then they must take it to DERCO, which checks the alignment with international law and South African international obligations. That is the first. Then second, what is developed is the President's Minute. And in that case, DERCO then requests to certify the final text, and then as well as text of the agreement. And then the President is requested to consider and approve the President's Minute, enabling the Minister of Trade and Industry to sign the agreement. And then the third stage is the cabinet approval. But before cabinet approval, the Minister of Sport, Arts and Culture is requested just to make an input, because it's not his department that generates the law. Then cabinet subcommittees look into it, and then the Global and the Continental Affairs Committee, GCAC, looks into it. And then we've got the Interministerial Committee on Intellectual Property, the IMC, which looks at it. And then International Cooperation, Trade and Security Cluster, ICTs, they look into it. And then Cabinet looks into it. After that, from Cabinet approval, then it goes to Parliament, starts with portfolio committees, then National Assembly, select committees, the Select Committee, and the National Council of Provinces. And then it goes to, then we look into, the depositing of that particular instrument, either the instrument of accession, that is whatever the country has agreed to in terms of international agreements. And then you then further look into whatever treaty sections at DERCO that this particular legislation is aligned to. And then we look into the way forward, which is then the president assenting to it into law and so on. So by the time, obviously there is a public participation process in between, prior to that. So that's why I say, whenever you hear anybody talk about copyright, you do not need the most experienced artists to comment on it. It's a pure legal science. And you need the legal minds to interact with specific provisions and not speak to it generally, as I cautioned in the radio debate that happened. Because some of the things that are raised in the debate have got nothing to do with the bill or with the act. They would have everything to do with what people's wishes are about culture, traditions, and happiness. And as you might know, when we had this debate with the Brazilian Senior Council, whether happiness is something that is justiciable. Can you take a matter to court on grounds that citizens are not happy? And then it was found that the South African Constitution promises its citizens well-being and not happiness. But other constitutions of the world, other jurisdictions promise their citizens happiness, and if they're not happy, they can go to court and raise the matter. Thanks.
Thanks so much, Dr. Khalani. The section you're referring to, I think it's section 30. You said 39. It's 39 of the Constitution, which obliges any interpretive enterprise journey to refer to international law, but consider as well foreign law. So it's a great point to making, because in the process of discussing the South African context, we mustn't lose sight of the international aspect and as well as the foreign law. And just on this platform, you touched on the originality and the creative spark, and the relationship there is grounded in section 39 of the Constitution, foreign law, as well as our country's law. Do we have anyone coming through to make contribution on this very important subject? Just come through, tell us who you are, and let's take it from there and engage Dr. Khalani. Welcome, anyone.
Chairperson.
Good evening.
Chairperson.
Okay, can we start with the lady, then we'll come with Mr. Malaji?
Oh,
You're prejudicing me, but it's fine.
no, you can go ahead and start, Mr. Malachi. It's okay.
Okay, evening. Thanks, my dear lady, for giving me the opportunity. My name is Mr. Din Malaji. I'm the founding member of the Horror Conversation. I wanted to check with Dr. Khalani to say to what extent, in a way, do you give such an informative information to the young and upcoming artists that are in maybe music industry per se, because that's the one that is often characterized with many allegations, be it of copyrights or of misinformation in terms of contract articulation and so forth. And juxtaposing that is also issues of the royalties, because we often at times when a known artist has departed, you'll find that that person is buried in terms of donations and so forth. So what kind of information do you perhaps, as the leading elders in the industry, do you impart to the young and upcoming artists, and how do you then teach them in terms of royalty issues to avoid dispute in future? I pause here.
Next.
Good evening to Dr. Khalani and everyone here. My name is Makhatla Tipalepale. Firstly, I would like to start with a comment to appreciate the so informative knowledge sharing from Dr. Khalani. Indeed, in quoting him to say that one thing that Philip Taban has left us remain definite is that it is very possible to influence others as much as it is possible to learn from them. So we have learned so much. Although some of us are not legal minds, but our eyes and minds have been opened in terms of copyright law. And also, I want to also applaud him on the work that he has done on Philip Taban. You would pardon me, Dr. Khalani, because I'm such a great fan of Philip Taban. So anything that I come across that speaks about him or written about him, I peruse. So thanks to the University of Pretoria repository, I came across your thesis on his work, which I believe is a book on its own. So I just want to, ask, is there any possibility of you writing a book on the life of Philip Tabani? more so that you have given a very detailed view of who Tabane was and his music, what his music entailed in the thesis. And also, I read somewhere that Philip Tabane once refused to work with Miles Davis because he did not want his Malombo, which he Malopo, sound to be diluted. So my question to you is that was he more sensitized on the issue of copyrights, old as he was, or was it just the issue of not wanting his Malopo sound to be diluted? And also the third question, which is the last, because the first question was that, do we have any possibility of you writing a book on the work of Philip Tabane and his life? And then the question is that I just posed. And the third, which is the last question, is that pre-1994, before democracy in this country, we have seen lots of musicians or artists in particular being exploited, some dying as paupers, some having to be, have to have donations raised to bury them, some who created so many hits, but even years after they are gone, we still dance to their music, but their families have got nothing to show. So even post 1994, we still have artists who are exploited. Some are not, they enter into contracts that they do not understand. Nowadays, you hear of automatic renewal of contracts, which is something that non-legal people like some of us, we are shocked to hear of such. So my question is, do you think that our government and also stakeholders like your music associations, artist associations, are they doing enough to sensitize artists, in particular musicians, about their rights, especially contracts that they enter into? Because you would understand that most artists are hungry. So as soon as somebody offers them contract, they quickly sign the contract. So do we think the country is doing enough to sensitize them to avoid exploitation of musicians? So before I take much time, I just want to, appreciate the information that you have really given us. I think you would make a very great lecturer. So one would attend a lecture session if you were to become a lecturer. Thank you so much.
Thanks so much. Let's stick to the two questions. We'll come to others, and we give Dr. Khalani an opportunity. This is not really a lawyers' forum. It's a forum which is inclusive of all members of society, and perhaps we need to sensitize the lawyers' forum about the great work of Philip Tabane. Of Ndate Khalani, because certainly society can benefit a lot if a lot of attention must be paid to his work. But then those were the questions from both Mr. Malachi and Ceci Mahata. Dr. Khalani, if you may come through.
Indeed, I must really apologize for keeping the tone of my presentation highly legal, but it's because it is the domain in which it belongs. It doesn't belong to any other domain other than that. So I had to use the language and the terminology and the precision of citation. And I might have sounded like I was saying section 13. I was actually saying section 39 because that section, I know it in and out. So if it sounded like 13, I meant to say 39. So workshops. Yes, I do run workshops. Last December, the Drakensberg Promotions requested me to, because what they do, they run the Moretele Festival, and then after Moretele Festival, then they call musicians they call them to the State Theatre, and then I facilitated that with Samro, Sampram, and Capasso, and so on. So I do that. I think now I probably did 7 or 8 conference presentations at the Moshito conference of the music industry. Sadly, all of it, it's either held at Sandton Convention Center or at the baseline in Johannesburg, and it hasn't gone to other provinces. But just yesterday, I was talking to a fellow citizen there in Polokwane who's putting together a proposal to have this thing done, where I would be invited to come and talk, and indicated that I'm talking on the subject today. So I'd be happy to do that. And please, anybody, please feel free to invite me so that we break it down. I might have pitched it at the level of the legalese, because partly I knew I was talking to legal minds. But often when I do these presentations where I do not have the kind of time I had here, I do, start with examples and go back to the principle, examples and the principles. So that's it. And I'm available really to be engaged. It does not have to be big groups, but sizable groups that we can talk to. We can then discuss. Now, the work of Philip Tabane, that work has been such phenomenal work. I did that work with passion. Normally, if you read most doctoral works, you'd find maybe they have about 5 chapters. But because that, I was writing it not for doctoral purposes, I was writing it for the record. And then I submitted it for doctorate. So I started doing that work in 1998 when I visited Dr. Tabane, and then I found that somebody who has bequeathed such character and integrity to a country, not to himself, to a country. If you go anywhere else in the world and you say Marombo or Malombo, as the Pretoria people call it, it's actually Marombo. It's a Chivenda word. They all say South Africa, Philip Tabane. Now you can imagine somebody who has bequeathed that to a country. And something that struck me was that he was the first person, when it was fashionable, everybody wanted to be known as a jazz musician. But he said, no. I'm playing Marombo, the music of the spirit. And then I asked him that, look, when I look at the 1963 a reportage in the world, newspapers and so on, and I found that he started that debate at the time. And then I wondered, why would such a man do this when it was fashionable? And even if people were not playing jazz, they would insist that they play jazz. Even today, people would say, here's a jazz festival, and when you look, there's no jazz musician there. I wondered why this man insisted. Only to find that I actually knew, and I learned a lot from him, that sticking to your guns in terms of being true to the soul of your nation and your people is the most profound thing you can ever do. But later, when I was touring different countries, and we went to the North Sea Jazz Festival in 1999, which was mounted from South Africa by the city of Cape Town, and the promoter was our brother Rashid Lombard. It was sponsored by African Harvest. And then we got there. We were the first South African stage ever in the history of North Sea Jazz Festival. And when we got there, we played a number of South African bands that came. And then we played with Slylo. We had a band called Taula from UCT, and then we played. And then after us, I think Moses Daiwomalelekwa, may his soul rest in peace, performed. And then Jimmy Lulu came, and then Cher All-Star, and then Mam Sylvia Mtunyela, the late Mankunku came on, and so on and so on. So when Moses came on and he was playing Ndademo Hall, and I was right at the back next to the sound engineers, we're done performing. And then there were two friends that signed my autograph, George Duke and Larry White. And they said, these are great jazz, musicians in the state. And they said, man, there's a beautiful music, man. What do you call it? And I said, well, back home, they call it South African jazz. They said, no, man, on a serious note, man, that's just beautiful. What do you call it? And I said, no, they call it African jazz. They said, no, man, we don't hear no jazz in the music. What do you call it? Now, that question, when South Africans thought they were playing jazz, and then the jazz gurus did not hear jazz, they had beautiful music. I realized that the biggest injustice we've done to ourselves is not to name the works that we do in the names of the source culture. Because every music of the world is derived from a culture. And then we then adapt. That's why when I started and I said I play free Kiba music, because it comes from Kiba music, Kiba indigenous. But once you put in guitars and pianos and so on, you cannot claim that it is Kiba music, because what you're simply saying is that you are supplanting, you are replacing the indigenous idiom with this one of your adaptation. And then you are saying people must look at your own more than they must look at the source that inspired you. So I wanted to leave the source in its integral form, so that I'm allowed space to interpret and adapt in a manner that I am able to. So, and I did that. So Philip Taman became the role model, because my first recording was in 1999, when the 35 years of Malombo National Tour that gave Philip Taman a doctorate by University of Venda was 1998, which I mounted with no funding from any institution whatsoever. So that is what I learned from Philip Taman, and that's why I wrote. And today, the academia peer review for journals report that more than 64 peer-reviewed journals have cited that work. You can imagine when 64 published peer-reviewed articles have cited that work, then it means there's something good about the work. The book, you raised an issue about the book. The book, I really have to do that. Let me tell you, I could not do that after I finished my degree because I had a lot to do. One, there was national duty that was calling in terms of writing the curriculum for arts education in South Africa, and was part of that. And then we did that. That's when we introduced indigenous African music into the curriculum from grade 10 to 12. So it was part of decolonization of the curriculum that we started. And I could not, then I had to study further beyond my PhD. Then I had to do some work, and including qualifying as a legal scholar. So basically, I had to do LLB and finish it, and then do the law school and do, all of those that are required. So I had to do that because I realized that this whole thing of being a great composer and a great performer will not assist this country. You need, moving from there, to go straight head on into litigation on matters of copyright and be able to fight the human rights battles on behalf of the people of our country as part of a patriotic act. So I had to do that. So I will get back to the book, indeed. And then, true, musicians die paupers because, indeed, You've got to understand literally everything I've just mentioned here today, literally everything and more. What I've said is like elementary introductory remarks on copyright law. And it is not something that should be understood by lawyers only. It should be something that any person who participates in the making of any of the 9 works should know it more or less as I do. Because in that case, you will not be, you don't have to have a law degree, but you must understand what some of the things that I've said here today. The music associations would talk about Samro, Sampra, Kapaso, just to mention a few. Indeed, they do run workshops and they do enlighten people. They've just had a conference recently, and they do call these conferences from time to time. And sometimes they do road shows, and I saw some minutes that they were in Polokwane at some point. But what we need to do is to engage them even post-conference and post-road shows, and invite the specialists there to come and run workshops for us, because they are available and they really do assist. And I'm also available to assist where I can. Thank you.
Thank you for now. I think the 2 participants who asked questions, they are questions which were interlinked, the exploitation of artists and how to interact with young artists, and the issues of royalties and people dying, I think those questions were interlinked. Yeah, but there's somebody who wanted to come in.
Tobela.
Emrana.
Am I audible now?
Yes, we can hear you.
Yeah.
But there's some sound behind you. We're not sure what it is.
Yeah, I'm in a public space. I had to move there because I couldn't connect the phone. But let me just be quick. Yeah, and thanks for this opportunity. And I must tell you, colleagues, that this is a great man. I'm one of his #1 fans, and he performed in my 2 most important days of my life. When I turned 50, he provided me with his whole band to come and perform at my 50th birthday. And when I turned 60, 3 months back, we were together. Now, I just want to check something. Why is it that in the era of CDs and DVDs, we struggle to get your music in shops? Was this anything to do with protecting your image, or exactly why is it that we struggle so much to get hold of your music? And then secondly, I'm asking myself, why are you not featuring in these awards that are all over the show? You know, the Summer Awards, the Metro, the MTN Awards. Is it? Are you refusing to be invited, or you just not attractive, or but why exactly are you not featuring in those awards, which I strongly believe you deserve? Thank you, Caleb.
That if I miss that, is it safe for me to say it's Dr. Sateche?
Yes, it is him.
Yeah, it is. You see, they have written NGK. I strongly believe that I think if you want to define me properly, call me Ngaka. If you call me Doctor, yes, Ngaka. NGK stands for Ngaka, and otherwise, Ngaka. Which when you say to people Ngaka, they will not ask what are you going to do, because they know what you are going to do. But if you say Doctor, it might be Dr. Halan, you see, and then it will then create a lot of confusion. So NGK stands for Ngaka.
Dr. Halan, perhaps there's a specific reason why I'm going to do what I'm going to do. May I request that you engage Ngaka Sateche, and then you can and perhaps advise this audience that is a very special human being who we are going to host, and advise them to join when we'll be hosting him. We'll be hosting him on a date we shall communicate. If you may, Dr. Alan.
Ge le be le theletsa Thobela FM go na le motho fela presenter tša maphelo ba re ngaka Nkalafe, and people did not know ngaka Nkalafe ke mang. Ke bona bo Dr. Sathege bo ngaka Sathege. Ngaka Sathege na nga le phala ge le ipitša ngaka nna le mpitše Kwankwetla. I'll tell you why. I said to Advocate Mantula Garman, I must start using the title ya Kwankwetla, because Kwankwetla it's a title that I was given. There are very few people in the country who received that. It's a very noble title. If it a doctor, because it was awarded by Hoshiradi Marapa, Les Chaba Saga Marapa. Ba file na ba fa Casta Semenya, ba fa Judge President Ngwepe, and a few other people. Na Bampechi that title for documenting, adapting, promoting to the whole world the concept Yakiba, and for doing academic work on the concept Yakiba. So for me, that is the biggest title. You know, Rogaru Udira, when you do work in a community that is the source community, the owners of the concept, and everybody else in the world recognizes your effort, and they don't recognize what your contribution, then you have not begun. But when they gave me that title, Kwankwetla, I was trying to figure out if I abbreviate it, will I call it KKT or KTL? So I'm figuring it out, but I will do that. So, Kwankwetla. Now, Yaraba question here the awards. The awards which we have moved, Rena, Babangu, we have moved from Kikumari was still in Chimbu Pilong Njele Disama. Disama holy somebody like me who owns a record company, owns a record label, who produces his work, who arranges his work, who produces his work, who publishes his work, who distributes his work. When you get you do not get nominated, you've got to apply and pay to participate. But for me, I did not feel it was necessary to play in that space. That space has got its own owners, and I'm happy with the work that they do, and it's good work for themselves. I got acknowledged. I think I've got about 13, if not 14 awards, where I was recognized not against somebody, not because I'm competing against somebody. You can't compete against somebody or given based on your uniqueness, because everybody else is unique. So nobody can compete with me, and I can't compete anybody on the gift and uniqueness. And so I have been honored for the uniqueness of the contribution I've done, where I am the only person who has done it. And And for me, those are the awards that I respect and honor, because you're recognized for what you've done, not against anybody, but because of the quality of the work that you've done in whatever you do. So I'm happy with that. And the availability of the music, it is the same thing. This is a highly contested terrain. There are people who have run a monopoly on this industry. And when some of us came in, they wanted first to take our publishing. When you submit your music and you register, you don't register a copyright. You notify the work that so that these people can come in as your witnesses in case of dispute, so that they check the dates and all of that. Then we were advised that no, but you can speak to so and so in this record company, is a great publisher. But South Africans, I know very few South Africans whose works were recorded by the world's greatest, because that's the work of a publisher. A publisher is supposed to pitch your work with the greatest of composers. For example, if Michael Jackson was alive and they pitched one of my songs for him to record, even if he doesn't perform it, if he prints 5 million copies and then I get $1 for mechanical royalty, I would have had $5 million. But people who keep royalties of, people who are publishers of most of the work of our people do not pitch it with the greatest of in the world. They just keep it. And you die and they own publishing. Publishing is the most important thing. So I'll tell you why, because when you record, I could record with the most gifted 5 of my peers, and they all pass on. I can re-record the work because I own the copyright, but it will never sound the same because those individuals have passed on. But those who have the energy and the brilliance of the first musician may not be me, because I would not be owning production rights. That's another right. Because the musical work, which is the CD, the master, would be owned somewhere else. So I avoided those kinds of things. And because I was able to tick all my boxes flat, it became difficult for the music to be available in stores, where the second leg of people was people who came forward to say, we can put your music in this shop, that shop, that shop, that shop, on condition we take the largest portion of the share. And then I said, please, can you get out of my face? I don't need you. And I was able to distribute and find access into quite a sizable number of stores. But at the moment, it's not easy to find the music of most people, because basically retail has collapsed in the country. So what's left is digital platforms. But the story of digital platforms, I will discuss it in brief another time, because it's a big sore on the bona fides of our own country, where we as a country do not own a digital platform of our own, where we can upload the music of South Africans and determine the price for downloading and get the whole world to download from us on our own terms. We could have survived COVID easily as musicians, because a lot of people all over the world would have continued to download on our own platforms. If your music is on other platforms other than the South African platforms, you are as good as the year 1933, where you would have to record and publish and release on a record label that was not South African. And when they leave with masters. The minute your work is out there on platforms that your country can't even litigate on, you're finished. So many of our people will realize much later that they would have no court to approach for not getting their money from digital platforms, because they would have voluntarily, willfully uploaded the music, and they did not know whom they were uploading with. because they were uploading simply with an app. Thanks.
Thank you so much, KK. It gets interesting. The other day, there was an interview somewhere of potential judges, but as they were discussing, the whole Judicial Service Commission came to agree that there's no single law that was named in the African language. Even the Witchcraft Act, our sign, is not named. It's not named in customary law, Customary Marriages Act as well. So, I mean, it goes to show that perhaps these titles, we need to visit them, and of course, what they mean to us. And thank for the lively interaction between Kwangbetlale and Ngaka Satechi. As we go to what's closure of the discussions, can we invite the last two people to come through, and for Dr. Khalani, just to note a question I have for him without a preamble. Can we visit the rights in the sense, or the works in the sense that Africans, we usually from one generation to the other, it's oral work mostly. So if it's not reduced to writing, why can't it be a right if there's evidence of such work coming from a specific individual, perhaps not reduced into writing? Is it something that we can work on as society and cause such to be protected in law? That's a question I have. But of course, the platform is open to everyone. If we can have two people coming through and give Dr. Khalani Kwangwe an opportunity to respond. Anyone?
Yeah, Mr. Chidi, let me perhaps briefly to come in to thank Dr. Khalani for such an insightful topic. Yeah, it's a really loaded one that most of us we perhaps take for granted. My question, Dr. Khalani, earlier when you spoke, you talked about most of our works, indigenous works, being stuck in European museums and all that. So I just want to find out from your knowledge, is there any deliberate attempt on any of the South African institutions, whichever one that is, has the ability can repatriate these works to do so? Is there such a deliberate attempt to repatriate these indigenous works back into Africa? Thank you.
And that is Mr. Kuyan, right?
Correct.
The last person, if we have any. The last person, if we have any, perhaps the last person is thinking about how to frame the question. I know somebody's going to come. Can we have a response, Dr. Khalani?
Very, very important questions. I'll end with yours. Let me start with the repatriation attempts. The attempts are indeed made, but they are not as fast and furious, and they depend from the gravitas from one administration to another. At least Rooibos has been repatriated in terms of IP, because it's a South African tea. At least to that extent, it was. Miriam Makeba's speeches. It was not one, it probably was there were 2 or 3 of them at the United Nations. Those speeches were repatriated. They are in our national archives. The Last Grave at Dimbaza by Nana Mahomo, it's a film that was written about apartheid murders and shallow graves that were dug in Dimbaza, has been repatriated. It's in the National Archives. Just to mention those 3, they have been brought back to South Africa, but they are still, you can imagine 400 years of colonization and or what political movements called settler colonialism. You can imagine all of those years, how much has been stolen, just to put it bluntly like that. How much was taken away from our shores? It's a lot. So we need to have a program. And then it cannot be that we will be naive, that we will not irritate the comforts of the countries that have our works, because it will affect diplomatic relations and all of that. But we need to be resolute as a country and then raise our stakes and our claim, and say that these are our works and we need them here. So it is very important that we do so. So my answer is that yes, the attempt, the process has been started way back, but it needs to be expedited. We need to move with speed. The question of how do we represent the issue of culture in our laws, besides customary marriage act and all other acts that regulate marriages and customary law. I made a submission at the Spring Law Conference 1914. No, what am I saying? 2014. When it is 2014.
No, I see you are about 94 now.
2014, I made at the cradle of humankind, I made a submission about us positioning African law as a very strong discipline of law, and not necessarily African customary law, but African law as an umbrella domain of law that would have sub-disciplines that would span all the disciplines from family law to public law. So that would go towards what you're saying. But as I'm saying, I want to rely on when these debates were going on, that particular question came out both in Parliament, it came out in public hearings about the current bill. And then there were a number of international instruments that were cited, and that we needed to have been part of in unequivocal terms. And these include, I want to quickly go to cite the domains of those international treaties that provide for, that would assist us if we had signed them. For example, the Beijing Treaty deals with the intellectual property rights of performers and audiovisual performers. It is administered by World Intellectual Property Organization. South Africa is not a member. World, that is WPPT, deals with the rights to two kinds of beneficiaries, particularly the digital environment, that is performers, actors, and then it deals with producers of phonograph. And then WCT deals with protection of authors of literary and artistic works. And then over and above that, you would have, for example, I want to cite what UNESCO. Well, first let's deal with WIPO, because you must first be a member of WIPO to then benefit from intellectual, from copyright law. It says traditional knowledge is knowledge, know-how, skills, practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. And then UNESCO says, on the other hand, it defines indigenous knowledge as follows, that it is an understanding, skill, and philosophies developed by societies with long histories of interaction with their natural surroundings. Both traditional and indigenous knowledge encompasses the skill and understanding, and both are knowledge which considered within communities or societies. So, because we derive, our laws derive articulation with international law, and it's very important for the participants that may not be legal scholars for us to distinguish between international law and foreign law. Foreign law is law of just a country next door or any other country. But international law would be the laws that come from international bodies like United Nations, African Union, SADC, and so on. So you would have those kind of treaties and agreements that buttress the basis of our law as international. So it is important that based on our participation in international treaties and our participation in international law from SADC, from African Union, that we, in the process of indigenizing our laws, we ensure that, and my argument was with other legal scholars, that we must first develop very strong common law. We could go for amendments, but we can also achieve that through common law. And I challenged the judges that were present at the Spring Law Conference that you are not assisting us with the reasoning of the courts. You know, when you pass a judgment, you deal with your legal question, and then you deal with the ratio decidendi, the reasoning of the court, the authorities you rely on to dispense a judgment. And I said, please, even if you can include proverbs, idioms, great sayings, wisdom of our people in the obiter, in the motivation of your ratio, of your reasoning of the court, of your authority that you rely on. Though in law they say it only has persuasive force, but sometimes the judgments that use that kind of a comment in the obiter dictum then would find slow, citation, and then in some instances it will be part of a minority or majority judgments. And then that's how we build common law and how we begin to build indigenous knowledge system in through the judgments, because judgments constitute our common law. And in the last 29 years, if we look at the judgments, except for one that presented in the Supreme Court of Appeal, the entire judgment in Sesotho, we do not have many that have done that. But the principles I'm talking about today, we've got two, we as legal scholars and practitioners and artists and all participants in the 9, we could stretch it that within the 9, how do we find ourselves represented in each one of them? And we must be cautious not to want to add the 10th, 11th, and 12th, which are exclusive for Africans. We must, within the 9 works that copyright law has conferred copyright on, in each one of them, we need to be able to locate ourselves. There was a point in which, in the Department of Education, for example, the writers of C2005 curriculum had written an outcome number 8 of creative arts as the development of indigenous African knowledge system. And when we were called in to contribute towards the writing of the creative arts, this thing, we removed it and we put in every outcome, we put African content. And then I was called to Johannesburg by a team that said, yeah, you removed that very, very, very important. I said, we do not want to be located in a Bantustan outcome that sits somewhere at the bottom of the ranking of all outcomes. We need to be in every outcome. And so is the situation in law. When we deal with issues of African content, we must not create a balkanization of African content somewhere. We need to find ourselves in every provision of the law. And we need to make sure that any other new bill that goes before Parliament, where are we in the bill? So during public comment, we need to be vociferous in the way we contribute. Thank you.
Thank you so much, Dr. Khalani. The last bite from anyone before we give Dr. Khalani an opportunity to say his parting words. Do we have anyone intending to engage Dr. Khalani, or are you satiated? You seem to be enough of great contribution. And of course, perhaps we should hit towards closure. Now, just perhaps to invite you just for a minute or so from your student life as an LLB student. Do you remember who wrote the material for customary law?
The prescribed books or the
prescribed book?
I think I suspect you're one of them.
No. I'm not. Unfortunately, I'm not. I wish I could go there, yeah. But if given the opportunity, I would.
I'm teasing you. I'm teasing you. I'm teasing you. Yeah. No. I just when you asked that question, I wanted to make another comment on the Makaresh Treaty, but just finish first, and then so that we then, in my closing remarks, I can then include it.
Now, the first part of the question is, would you remember who's the author of the prescribed material you had to rely on for the purpose of customary law?
There are a number of them here. Part the jurisprudence one, some of it is there. Let me quickly look.
We are in the library.
No, I'm in my study.
Yes, the study.
Yeah, so I've got quite a few here that I can put to you. Right. Yeah, there are a number of them here. Who would you like us to start?
Yeah. No, that's the first part of the question. The second part, and I'm saying this because the book I read, I'm not sure whether that is the case when you did LLB, Dr. Alan.
Oh, the two of them were not written by Africans.
They were not written by Africans. Did they quote their sources?
They were customary law, but they were two non-African professors.
Yes, and would they have known what they wrote from lived experience or possibly learned from others in your imagination?
No, in my imagination, they didn't. I mean, I can imagine just deal with the customary law in itself, and then deal with you know, the what is defined clearly as a African marriage that meets the requirements of a properly constituted marriage. If I take those books there and I look at the professors there, you would find that certain elements you really cannot associate with simply because of your lived experience, and the intricacies of our cultures and would have been represented in broad strokes, and the certain presumptions of law that emanate from the practice of what constitutes you know, a couple in our terms would not be a presumption that people have been living together for some time and are known by neighbors as wife, you know, husband and wife, and therefore based on that, the presumption of law is that they are the husband and wife. And you would look at most of the examples that are given there, you would realize that they've also moved from an assumption that some of the contexts are contexts that are defined against Western religions, not in their own right, but against, you know, they are kind of juxtaposed, and they look like they are give space to qualify to be, instead of moving from an Afrocentric perspective and define marriage from that with all its intricacies. So basically, it is not, as we say, the insider's perspective.
Yeah. It's unfortunate. I'm not sure whether we're going to be cut now exactly at 8 o'clock because the administrator of this program has network challenges, couldn't join us, and we are left with a minute. If we are cut, then that would be the end. If we are not, for up to 8:05, we can go on and just conclude on this point and invite you to say whatever that you want to say, Doc, and we close off at that point. Now, it's almost 30 years. Next year is 30 years. For African law or customary law, we still rely on non-Africans. Isn't that a problem?
It will remain a problem. That is why when I joined the space of musicology, I defined things. I chose the methodology quite carefully. I said ethnographic approach, which is the participants' own rules of interaction and participants' own rules of interpretation of what it is that they're doing. So I immediately drew a line from all other sources that are not participants themselves. So it's very important that people who do research, that your methodology will sell you out. So I chose that one. So even in law, we need to do more of ethno-legal science, where the participants themselves, what the rules are of their interaction on a communal matter, and what the rules are of their interpretation of that communicative event of a communal matter. Then we will have a new angle of legal science.
And why would a university, possibly well aware that the author of content sourced it from somewhere, but does not acknowledge the source, why would they prescribe such a book? Because they've got a term, I don't want to go there, they use, and they say it's offensive, it's in the academia. But why in the process would they prescribe such material?
Well, you know, academia judges people by rank. If a professor says it's a good book, then it becomes a good book. If it's rated by fellow professors as a book that is meritorious in its content and so on, but if you look at it, education is ideological generally. So people may argue and say, no, it's not. It's scientific. No, even scientific methodologies are you know, lined with all ideological streaks. And I once did an experiment. I went into this class, I sat in front, and I wrote a jurisprudence article. And then I got 9.5 out of 10. Because I said, you see, law must be balanced. There must not be, you know, an idiosyncratic perspective and so on. I got 9 out of 10. And I already had a doctorate at the time. So I knew exactly the game, what to play. And the next assignment, I deliberately moved it from a revolutionary, from an African perspective, and I got 3. And then I said, yeah, no, you did not know, I caught you. Now I know what you want. You want something that does not debunk existing notions.
Thank you so much for that opportunity to engage on this. And what I wanted to drive, and of course, perhaps we may not discuss that, is that in my view is plagiarism. It's plagiarism because you go into a community, you learn how they go about living, and their structure of life and the society, how they go about solving problems. You go record it, but you do not say that you learned it from a specific community. In my view, it's plagiarism, and it's not supposed to be promoted by universities. But obviously, those are the challenges we have because it's very difficult to be an African in this country.
Yeah, I want to say on that, I wish you could access my master's research from UCT. My authorities were communities from Rampatlele, from Seshego, from Garadingwana, in Rampatlele, from Sikukuni, and so on. So, because there was nowhere I could read about how to tune Dinaka. And the men who told me became authorities because those are the people who went into the bibliography. Because they're authorities, and because the methodology I chose had allowed me to cite them as authorities. So it is one thing. There was a professor, Mekin Zewi, at University of Pretoria, who published a book and cited some of the key informants in traditional communities as co-writers of the book, which is what he wrote post his doctorate, and he wrote a book. So if I were to write a book on Philip Tabane, because he informed quite the largest part of this, so it's going to be, it's a pity that academia will not accept that I say Philip Tabane and Dr. Khalani, or Philip Tabane and Sello Khalani. They would want me to say Sello Khalani, and if I include him, and say, but you know, when you cite work, the first author, then is cited, and then you say et al. So these people must not fall under the et al. We who compiled based on what they informed us must fall under et al. But also let us understand that the epistemologies, Western epistemology, which is basically what defines most of the academic work, and then African epistemology, which is still fighting for space and for the center's stage in every area of knowledge, not just in law, in every science and mathematics, in languages, everywhere. Everybody in this country must be on their feet, be conscious 24/7, check out for the lies and derobe the content of the lies, so that anything that you, and I'm appealing to people who do research in masters and PhD, you have the first 2 opportunities in your entire life to write what you would have wanted to write when you were a child. And most of our people, you know, just join and write, you know, pedantry, you know, academic work that relies on a lot of references, and they forget to put their own voice in the, and then they raise their own voice outside. And then when they write, they don't put it in. And that is a travesty, because we need to do more, you know. Would rather publish books that do not go through peer review, but make sure that the coming generations are able to read some modicum of truth, even if in academia they say truth is relative, but we know the truth.
Thank you so much. We are here in Polokwane, and we are on YouTube Live. It's going to be recorded. You can access it at any stage. Kwangwetla, we are not too far from Hamjaji. Hamjaji, they make hula fall. Can we fix your content for 30 seconds and make hula fall just for this audience? Just 30 seconds. We'll not steal that content. I know the person who enjoys it most is Naga Sateche, but can we share with you just a little, 30 seconds?
Of what, of Pula?
Yes.
It's a difficult one. Do you want me to sing it, or do you want me to play
it? I know I'm naughty. Any of the two, which is best, and silly as well. But forgive me for that.
No, what I can do, because this is a world of ideas. What I can do is that just to explain that Pula represents rain in a literal sense. It represents rebirth. It represents rejuvenation. It stands for posterity. It stands for prosperity. Because when the rain falls, and when our people make the call, and they say Pula, and then we say Aine. Often when I make this call in festivals, when you've got 20, 30,000 people, 18,000 people, all in one voice, and they say Aine, it literally rains, because there is no way that the creator would hear 18, 20, 30,000 voices at the same time say Aine, and it doesn't rain. So the significance of the power of solidarity, and that's when we then are able to sing with glee and say, Yana Pula ye, aye yelele, Yana Pula ye, aye. Thank you.
Thank you so much. And we'll make it rain on Sunday when Sundowns hosts another team from Africa. You know, they sing Yana Pula, and I think they were following your leadership. Thank you so much for having us tonight. We'll share with you the link, everyone who's here on this platform. And we don't have many ways to thank you. Maybe as appreciative words, perhaps from Ndate Kubiana or Ndate Malachi. You can say thank you to everybody, including Dr. Khalani. This is my last bite. I'm not going to be here anymore. Any of the two? The leadership of the association?
Thanks, Chairperson. If it was within my powers, I would have extended it for 5 hours so that we can be pregnant with information. But having said that, ka nnete pula ya knowledge ya re neele modimo a re babalele yena ntate Dr. Khalani re a leboga.
Thank you so much, everybody. This is the end of the. Sorry.
Ke re go leboga nna ke a leboga. Ka Sepedi ba re a
Wangweta.
Majijara leboga kwa ngwetla ene batho ba Limpopo ba tshwantse ba dire mmereko wa bona re ye kwa maraba kwa le tle mo re bine re a leboga kiwa.